Trump's legal team sat in stunned silence as federal judge Catherine Morrison delivered a warning from the bench that legal experts are calling unprecedented in its directness and severity. During a routine scheduling conference on February 9th in the Southern District of New York, Judge Morrison stated that she had reviewed preliminary evidence in the fraud case and that any attorney who knowingly presents false statements to her court would face immediate sanctions, including potential disbarment referrals. And this wasn't standard judicial admonishment or procedural warning. This was a federal judge with 23 years on the bench directly signaling that she believes defense filings may contain materially false representations and that she will hold attorneys personally accountable. When a judge interrupts a scheduling conference to issue warnings about attorney conduct before any substantive motions have even been filed, you know something extraordinary just happened. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this remarkable judicial intervention? Court filings from February 7th show that Trump's legal team submitted a motion to dismiss the fraud case, arguing that financial statements at issue were protected by attorney-client privilege and that valuations reflected good faith business judgments rather than fraudulent misrepresentations. But prosecutors had already obtained emails through separate subpoenas showing that attorneys were warned by internal accountants that specific valuations were unsupportable and that continuing to use those figures in financial statements would constitute fraud. When Judge Morrison reviewed both the defense motion and the contradictory evidence prosecutors submitted under seal, she called an immediate conference. Multiple attorneys who attended the February 9th conference told reporters that Judge Morrison's tone was unlike anything they had experienced in federal court. She began by noting that she had presided over complex financial litigation for more than 2 decades, and that she recognized the difference between aggressive advocacy and statements that crossed the line into misrepresentation. She stated that defense filings characterized the valuations as reasonable business judgments made in good faith, but that evidence before the court showed internal communications where those same valuations were described by experts within the organization as indefensible and likely fraudulent. Judge Morrison then did something that veteran trial attorneys say they have rarely witnessed. She read portions of the defense motion aloud in open court and contrasted them with specific emails and memoranda that prosecutors had filed under seal. She noted that the defense motion stated that all financial statements were prepared with input from qualified professionals and reflected accepted industry practices, but the sealed evidence included an email from a certified public accountant employed by Trump Organization warning that property valuations were inflated by 300 to 400% compared to independent appraisals, and that using those figures to obtain loans would constitute bank fraud. The judge stated from the bench that when defense counsel files sworn declarations stating that valuations were prepared in good faith, while evidence shows internal experts were simultaneously warning that those valuations were fraudulent, the court must question whether counsel is making good faith representations. She emphasized that attorneys have ethical obligations that supersede client loyalty, and that officers of the court cannot present arguments they know to be false. Smash that like button if this is making sense so far. Here's where it really gets serious. Judge Morrison didn't stop at general warnings about ethical obligations. She specifically stated that she was ordering defense counsel to personally review all internal communications related to the financial statements at issue and to certify in writing that they had done so and that their representations to the court remained accurate after that review. This certification requirement puts defense attorneys in an impossible position. If they certify that their representations are accurate despite contradictory internal evidence, they risk sanctions and potential criminal liability for making false statements to a federal court. If they withdraw or modify their representations, they essentially concede that prosecutors are correct about the fraudulent nature of the financial statements. Legal ethics experts told reporters that this kind of certification requirement is extraordinarily rare and represents a direct challenge to defense credibility. Attorneys are required to have a good faith basis for arguments they present to courts, but judges rarely require them to certify that they have personally reviewed underlying evidence supporting their claims. By imposing this requirement, Judge Morrison is forcing defense counsel to either stand behind their representations with personal accountability or back down from arguments that the evidence contradicts. The courtroom atmosphere during this conference was described by multiple attendees as tense and uncomfortable. Defense attorneys attempted several times to respond to Judge Morrison's statements, but she cut them off and stated that this was not a debate about the merits of the case. She emphasized that she was addressing a threshold question of whether counsel was making representations to the court that were consistent with evidence actually in their possession. She noted that if attorneys had not reviewed the internal communications that prosecutors obtained through subpoenas, they needed to do so immediately before making further filings. One defense attorney attempted to argue that the emails cited by prosecutors were taken out of context and that when viewed in totality, the record supported the position that valuations were reasonable. Judge Morrison responded that she had reviewed the full email chains and supporting documentation, and that context did not alter her concern about potential misrepresentations. She stated that she was not making findings on the ultimate merits, but that she was putting counsel on notice that their filings needed to be consistent with the full evidentiary record, or they would face serious consequences. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. The judicial warning has immediate practical consequences beyond just the ethical concerns. Defense attorneys who believed they could argue aggressively that all conduct was lawful and appropriate now face personal liability if they make representations the evidence contradicts. This fundamentally changes litigation strategy because attorneys must now calibrate their arguments not just to serve their clients' interests, but to protect their own professional licenses and avoid potential sanctions. Former federal prosecutors told news outlets that they have never seen a judge so directly warn defense counsel about potential misrepresentations before substantive litigation had even begun. Typically, if a judge believes filings contain false statements, she might issue sanctions after the fact or refer the matter to disciplinary authorities. But warning counsel in advance that their filings appear inconsistent with evidence and requiring personal certification creates immediate pressure on defense attorneys to reassess their strategy. The certification requirement also creates a paper trail that could be used against defense attorneys if they continue to make representations that evidence contradicts. If an attorney certifies that they have reviewed internal communications and that their representations remain accurate, and it later emerges that those communications directly contradict their sworn statements, that certification itself becomes evidence of knowing misrepresentation. Legal ethics experts note that attorneys can face discipline not just for the underlying false statement, but for the false certification that they had reviewed evidence supporting their claims. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And here's what makes the situation exponentially worse for Trump's legal defense. Several attorneys on the legal team are already facing disciplinary proceedings in other jurisdictions related to their work on election challenges and other Trump-related litigation. State bar associations in New York, California, and the District of Columbia have active investigations into whether attorneys made misrepresentations to courts in those cases. If Judge Morrison's certification requirement results in findings that attorneys made false statements in the fraud case, that becomes additional evidence in those separate disciplinary proceedings. Sources close to the legal team told reporters that the February 9th conference triggered emergency internal meetings to assess how to respond to Judge Morrison's warning. Senior attorneys are reportedly reviewing whether the litigation strategy needs to be fundamentally revised, and whether some attorneys should withdraw from the case rather than face potential personal liability. The problem is that withdrawal at this stage creates its own difficulties. If experienced attorneys withdraw shortly after a judge warns about potential misrepresentations, it signals to observers that those attorneys concluded they could not continue to make the arguments the client wants while complying with ethical obligations. The timing of Judge Morrison's warning is particularly significant because it came just 3 days after the classified congressional briefing that triggered 23 Republican senators to withdraw their support for Trump's defense. Legal analysts note that federal judges often communicate informally with other judges and with prosecutors about ongoing cases. While Judge Morrison would not have access to classified congressional briefings, she would be aware through normal judicial channels that other courts had found evidence of systematic misconduct, compelling enough to justify extraordinary preliminary relief. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone following this story. Judge Morrison's warning was not limited to the specific fraud case before her court. She stated from the bench that she had reviewed filings in related cases in other jurisdictions and that she observed similar patterns of defense representations that appeared inconsistent with documentary evidence. She noted that while she had no authority over proceedings in other courts, she was concerned that a coordinated litigation strategy might involve making representations across multiple jurisdictions that could not all be simultaneously true. This statement suggests that Judge Morrison has been coordinating with other federal judges handling Trump-related litigation. Former federal judges told reporters that while such coordination is not common, it does occur in complex cases where the same defendants and attorneys are litigating similar issues across multiple districts. Judges may share concerns about attorney conduct or litigation tactics that appear to abuse the judicial process. If multiple judges have similar concerns about defense representations, that coordination could result in uniform requirements for certification or heightened scrutiny of defense filings. The prospect of facing similar warnings from judges in other jurisdictions creates a nightmare scenario for Trump's legal team. They are already defending against investigations and litigation in New York, Florida, Georgia, and the District of Columbia. If judges in each jurisdiction start requiring personal certifications that filings are consistent with all available evidence, defense attorneys would need to conduct exhaustive reviews of massive document productions before making any arguments. This would slow down their ability to respond to motions, increase legal costs dramatically, and potentially force them to withdraw arguments they believe are important to the defense. Legal experts emphasize that Judge Morrison's warning reflects broader concerns about litigation tactics that have emerged in high-profile political cases over the past several years. Courts have watched attorneys make aggressive claims in public forums that they then failed to support with evidence when required to do so under oath in court. Judges have become increasingly frustrated with what they see as a disconnect between public statements and sworn filings. By requiring personal certifications and warning about sanctions, Judge Morrison is essentially demanding that defense attorneys operate with the same standards of truthfulness in all contexts. The February 9th conference transcript, which was publicly released on February 10th, has already become required reading in legal ethics courses at several law schools. Professors are using it to illustrate the tension between zealous advocacy for clients and attorneys' obligations as officers of the court. The transcript shows Judge Morrison explaining that lawyers serve two masters under the American legal system. They owe duties of loyalty and confidentiality to clients, but they also owe duties of candor and honesty to courts. When those obligations conflict, the duty to the court must prevail. Things escalated further when the lead defense attorney attempted to argue that requiring certification before the court had made any findings on the merits was premature and potentially prejudicial. Judge Morrison rejected that argument emphatically. She stated that certification requirements are appropriate whenever a court has reason to question whether filings are consistent with available evidence. She noted that she was not making findings on the ultimate question of fraud, but that she had a responsibility to ensure that arguments presented to her court had a good faith basis in fact and law. The judge then did something that legal observers found remarkable. She stated that if defense counsel believed they could not certify that their representations were consistent with all available evidence, they should inform the court immediately so that she could consider whether to appoint independent counsel to verify the accuracy of defense filings. This suggestion that the court might appoint independent counsel to fact-check defense arguments is virtually unprecedented in civil litigation. It signals that Judge Morrison is prepared to take extraordinary measures to ensure that proceedings before her court are conducted with integrity. If this blows your mind, hit that like button right now. Here's the situation facing Trump's legal team. They received a direct warning from a federal judge that their filings may contain misrepresentations. They are required to personally certify that their arguments are consistent with all available evidence, including internal communications that prosecutors obtained through subpoenas. They face potential sanctions, including disbarment referrals, if they continue to make representations that evidence contradicts. And they are defending similar cases in multiple jurisdictions where judges may impose similar certification requirements. Former defense attorneys who have handled high-stakes federal litigation told reporters this is the worst possible development for any legal team. When a judge signals from the outset that she questions your credibility, every subsequent filing receives heightened scrutiny. Arguments that might normally receive the benefit of the doubt are instead treated with skepticism, and any inconsistencies between your representations and the evidence are likely to result in sanctions rather than being overlooked as the normal give and take of adversarial litigation. The warning also affects litigation tactics going forward. Defense attorneys often file aggressive motions to dismiss, knowing they are unlikely to prevail, but hoping to narrow the issues or establish favorable legal precedents. Under normal circumstances, courts tolerate this kind of aggressive advocacy as part of the adversarial process. But when a judge has warned that she will sanction misrepresentations and required personal certifications, defense attorneys must be much more cautious about what arguments they advance. This defensive posture often results in weaker advocacy and worse outcomes for clients. The financial implications compound the legal difficulties. If senior attorneys withdraw from the case because they are unwilling to make certifications that Judge Morrison requires, Trump will need to find replacement counsel willing to take on a case where the judge has already signaled skepticism about defense credibility. Experienced federal litigators who might normally be willing to represent controversial clients may decline when they know a judge has issued warnings about potential attorney misconduct. Less experienced attorneys who do take the case will need to spend significant time getting up to speed, increasing legal costs while potentially providing less effective representation. Stay with me. What comes next will completely change how you view the situation. Legal scholars are calling Judge Morrison's warning a potential turning point in how courts address attorney conduct in politically charged litigation. For years, judges have expressed frustration privately about aggressive defense tactics in high-profile cases, but have been reluctant to impose sanctions because of concerns about appearing biased or interfering with defendants' right to vigorous representation. This warning suggests that frustration may be reaching a breaking point. A former federal magistrate judge told legal publications that Judge Morrison's approach represents a generational shift in judicial thinking about attorney obligations. Older judges often gave attorneys wide latitude to make aggressive arguments, even when the factual basis was questionable, viewing such advocacy as part of the adversarial tradition. But judges who came of age during an era of increased attorney discipline and heightened concerns about litigation abuse are less tolerant of arguments that stretch or misrepresent evidence. They view their role as gatekeepers, who must ensure that judicial processes are not abused for tactical advantage. The immediate practical effect is that Trump's legal team must now decide whether to comply with Judge Morrison's certification requirement or challenge it through appeal. If they comply and certify that their representations are accurate, they assume personal risk that subsequent evidence could prove those representations false. If they decline to certify or modify their representations, they essentially concede that their initial filings were not fully supported by available evidence. And if they appeal the certification requirement, they delay substantive litigation while drawing additional attention to judicial concerns about their credibility. Legal experts note that appealing a certification requirement is tactically difficult because appellate courts give trial judges wide discretion on case management issues. An appellate court would likely affirm Judge Morrison's order unless it was clearly an abuse of discretion. And arguing on appeal that a trial judge abused her discretion by requiring attorneys to certify that their filings are accurate is not a strong position. It invites the obvious question of why attorneys would object to certifying the truthfulness of their own representations. Here's what multiple legal experts emphasize. Judge Morrison's warning does not determine the outcome of the fraud case. Trump may ultimately prevail on the merits if prosecutors cannot prove their allegations beyond the required standard of proof. But the warning fundamentally changes the dynamics of how the case will be litigated. Defense attorneys must now operate with the knowledge that the judge is skeptical of their representations and prepared to impose sanctions if those representations prove false. This creates pressure to be more careful and less aggressive in legal arguments, which generally advantages prosecutors. The psychological impact on defense attorneys is significant. Former litigators note that receiving a direct judicial warning about potential misconduct affects how attorneys approach every subsequent filing. They become more cautious, run arguments past additional reviewers, and avoid making claims that might be questioned. This defensive posture often results in longer briefs, more hedged arguments, and less effective advocacy. When you are constantly worried about potential sanctions, you cannot advocate as forcefully as when you are confident the judge views your representations as credible. Sources familiar with internal defense team discussions told reporters that the February 9th warning has triggered serious conversations about whether the current litigation strategy is sustainable. Some attorneys are reportedly arguing that the team needs to make significant concessions on factual issues to maintain credibility with Judge Morrison and avoid sanctions. Other attorneys are insisting that making concessions at this stage would be devastating to the defense and that they should continue to fight aggressively despite the judge's warning. These internal tensions are creating dysfunction that further undermines the effectiveness of the legal defense. Pause for a second and hit that like button if you're finding value in this coverage. Here's where things stand right now. A federal judge has issued an unprecedented warning that defense filings may contain misrepresentations. She has required personal certification that arguments are consistent with all available evidence. She has threatened sanctions, including potential disbarment referrals for false statements. And she has suggested that she may appoint independent counsel to verify the accuracy of defense filings if attorneys cannot provide required certifications. This isn't another routine court proceeding that will fade into the background of normal litigation. This is a direct challenge to defense credibility at the outset of major fraud proceedings. The judge has signaled that she questions whether attorneys are making good faith representations. She has created personal liability for any attorney who certifies the accuracy of filings that evidence contradicts. And she has indicated that she is prepared to take extraordinary measures to ensure proceedings before her court are conducted with integrity. What happens next could determine whether courts continue to tolerate aggressive defense tactics that push ethical boundaries in high-profile political cases, or whether judges will increasingly impose certification requirements and sanctions to enforce higher standards of attorney conduct. The warning has been issued, the certification requirement is in effect, and defense attorneys must now decide whether to comply, modify their arguments, or challenge the judge's authority to impose such requirements. Keep watching this story closely because the implications extend far beyond one case. This could reshape how attorneys approach their obligations in politically charged litigation for years to come. The stakes have never been higher, the judicial scrutiny has never been more intense, and the legal team has never been more vulnerable to sanctions.